Okay, then we'll make a start, guys. So I'm Reagan Persaud. I am a barrister in Leeds at Spy Barristers, and I specialise entirely in children law, and I probably do about 10%, if that, private children, and the rest is care. So this is my bread and butter in terms of dealing with these kinds of proceedings, final evidence from social workers, and just social working generally, in terms of care proceedings. I also do probably about 80% of my practice is local authority work. So I've got a decent idea of what sort of things we should be looking for in this. And so I thought it might be sensible for me to do this session, A, because I think it's beneficial to you guys, but B, because it helps when you have the insight of being in court to know what kind of things will be criticised, what kind of things will cause difficulty, and a bit of feedback on the other side to assist in better writing is always helpful. Now, I know that there are many lawyers on this, many solicitors from the local authorities, and you'll have to forgive me in advance because I did aim this session more at social workers to make sure that they have a better understanding of how to write final evidence. So if I am teaching you to suck eggs, please forgive me. I'm sure you'll learn 1 or 2 pointers, if nothing else, but I suspect most of you are pros at getting final evidence in order. So without any more difficulties, we'll make a start. I'll just double check that chat because I've seen a couple of people message, and by all means, just keep sending messages throughout because I can keep glancing at the chat and I'm responding. So didn't get the handout. So what I'm going to do is in the chat box, if you haven't got the handout, I'll put my email address, and as they come through, and as I am speaking, I can send the handouts out to you, but I can't type people's email addresses in. That will distract me. Whereas if you email me, then I can just press reply, can't I? And that will probably be the easiest way to tackle it. So that's spybarristers.co.uk. Yep, send. So there's my email address. If anyone hasn't got it, I'll keep an eye on my emails and we'll go from there. Okay, so if we turn to the handout then, what we're going to cover today in terms of learning objectives, we're going to briefly cover some relevant legal principles. I should also say, and I hate saying this, but I shall refer you to Spy Barristers' YouTube channel, where I've covered quite a few seminars now, and there is a breadth of legal guidance, seminars on different legal topics, primarily aimed at social care and solicitors and local authorities. So I'm going to sort of highlight some relevant legal guidance here, but I actually think it would be helpful for you to refer back to those seminars and have a listen there. And of course, we keep billing the YouTube channel because I do one of these every month. What we're then going to do is look at what issues, considering the relevant guidance, what issues does your final evidence need to address, the application of the checklist, the importance when writing of being balanced and the role of the balance sheets, dealing with expert evidence, and I'm going to then give you some doing it right tips and make sure you cover these kind of areas when you do it. So let's start with relevant legal guidance. And solicitors, close your ears because this will be very obvious to you. Remember, when you write and whenever you present something as a social worker, as a local authority, the burden of proof is on you. And your evidence, your statements are the evidence in the case to prove your case. What you can't do is make decisions based on suspicion or speculation. You have to prove your case. And that's all the more important why the final evidence needs to be crystal clear as to the plan and your reasoning and how you get there. Remember the importance of primary evidence, and for any social workers on the line, primary evidence is what comes out of your mouth. It's what you've seen, what you've observed, and what you then say. If you are only conveying in writing something school has told you, well, that's hearsay evidence. It's not something you've seen yourself. It's something that school is conveying. And I always like to point out the REA case on this one, because it says there, any findings of fact must be based on evidence and not suspicion. If the local authority is challenged on something, it must deduce proper evidence to establish what it seeks to prove. Now, what that means is get your primary evidence in. The court, the most reliable evidence that the court can have is the evidence from the person who saw it, is the evidence from the person who hears it. And I do think that is important in writing, and I'll come on to why that is in a moment. But remember that when you write these statements, what is primary evidence and what is hearsay evidence needs to be crystal clear so that the court knows what weight to attach to what. Okay, so the second issue in the legal side I want to discuss with you are the two checklists, the welfare checklist and the adoption checklist. And again, the reason I want to mention them and spell them out is because when you will write your final evidence, you will have to use one of the two checklists to justify your plan to the court. And quite often, in fact, a little too often, I see cases where we get to the door of court and the social worker has applied the welfare checklist in a plan of adoption. Remember, if your plan is adoption, it is the adoption checklist. And for solicitors who will review final evidence, this is one that sometimes slips through the cracks. And actually, I pick up a lot of cases as counsel going to the IRH or the final hearing, where for the first time ever, it's noticed that the social worker has applied the wrong checklist. So I think from a legal side, that's one to keep an eye on. I'm sure lots of you do. But for social workers, remember, the right checklist is very important. Now, on a plan that's a bit nailed on, and I think you all know what I mean by that, on an adoption plan that's nailed on with a really powerful parenting assessment and a child who's 6 months old with no alternative carers, you might get away with it. But on a plan where you might come into conflict with the guardian, for instance, the court is likely to criticize you for applying the wrong checklist, saying that your evaluation is therefore wrong and more weight needs to be given to the guardian's analysis because the guardian has applied the right checklist. So I point that out simply to say, bear in mind that getting that wrong can have consequences. And in some cases where in particular you end up in conflict with the guardian, where the guardian might be saying, no, long-term foster care is better over adoption, that can really bite you in terms of how you present your case. So get the right checklist in there, and we'll cover that in more detail in a moment. And I think that is all there is for law. So solicitors, this is your chance to sit back and go, I know that, Reagan, and I know that, Reagan, and I know that, Reagan. For the social workers, get your pens out because we're going to cover some important stuff. Okay, so what issues does your final evidence need to address? So I think you all know what a SWET is, the social worker evidence template, and it gives you these headlines that you just fill in. In theory, if you do it right, you've written a really powerful piece of final evidence. But try to stick to the headings because I think that gives you clear guidance. What I would say is, in your final evidence, that's your statement and your care plan, be wary of producing inchoate care plans. What I mean by that is a care plan that isn't clear, is a care plan that doesn't tell us what the long-term option for a child will be. So, for instance, I have a case at the moment where the care plan for the child, basically, the child has very difficult behavioural issues and psychological issues. And so the expert has recommended a residential unit as a placement. As you can imagine, that causes concerns in the authority. And what they've done is they've put in a plan that basically says, please give us a care order and we'll keep looking for a replacement. And what they don't do is say, is that a foster placement? Is that a residential placement? Are you respecting what the experts have said? And they've glossed over that. Of course, the court has found that is inchoate, and it's inchoate because what is the plan? Where are you putting this child long term? So bear in mind that when you put these plans forward, it needs to be very clear what order you're seeking, where the child's going to be, and what the contact proposals are going to be, because then the court will know exactly what you're saying and you can avoid that criticism. And I always think in the first part of the social worker statement, you can say that in that first section that says what's the local authority's plan, be as clear as you can about that. Threshold, and in the SWET, it actually says local authority threshold or something like that. Now, my view on this as counsel is that social workers have to be careful what they say about threshold. I entirely accept that it will be a document drafted that you will approve, and solicitors will either draft it or counsel will draft it. But if the social worker writes it into the statement, she can then come, or he can then come under fire for that. Say, for instance, if they use an old threshold document, if they miss out a particular factor, if they include something that we've decided to take out of threshold. And I always think, don't try and circumvent what threshold should be, or don't even try to put it in the statement. Just say, the court is respectfully referred to the accompanying threshold document, or the threshold document prepared on behalf of the authority dated blah, and leave that as the only thing you say about that. Because I have seen social workers in the witness box be criticised because they put something in that isn't the authority's position on threshold. So if you're a social worker, I think less is more when it comes to that section of the statement. Bring the court up to speed with events during proceedings. So a brief chronology. You've done your chronology at the start of the case, so you just want to go through it sequentially and say, since the issue proceedings, this happened, this happened, this happened. Do it chronologically. That's why I write chronologically. Think of the most important incidents when you do that, because what we don't want, and what judges always criticize, is a 30-page sweat. I think sweat should be 10 to 15 pages max. Obviously that depends on how many children you have and their needs and such. But think of the most important incidents during proceedings, and that's your chronology. And then apply the correct checklist, which we will cover in more detail. So let's turn to that checklist and what you've got to do with that. Remember to apply the right one, and remember that every child is an individual. And what I mean by that is you cannot just throw the checklist in and say these children are at risk for these reasons, these children have these needs, these children have this, these children need that. Apply it for every child. So what's a common name that comes up in 300 cases? Let's go for James, and let's go for Lily. They're common names, aren't they? Never group James and Lily together. Say Jilly. I just did it myself. James requires this, this, and this care. Lily requires this, this, and this. Even if they're the same care, I would always differentiate with the two headings so the court is clear that you've applied it individually to every child and you haven't grouped them together, which is sometimes what happens when we make that mistake. Now, why are we applying the checklist? Well, because it's the relevant law for the court. It's what the court's going to consider and give judgment on to decide if they agree with you or not. And remember, you are the expert. What I mean by that, social workers, is that you are the expert with the lower E. You are the one that's going to tell the court what's right for the child. Of course, the guardian will have their 2 pence to throw in, and of course, you will get challenged on it if a parent disagrees. But when it comes to thinking of yourself as an expert, I want you to remember this. You have to therefore be balanced. I've seen time and time again social workers get criticized in the witness box because what they do is they use the checklist to justify their plan. What I mean by that is, I'll give you a very good example, and I think it's on my list of examples: contact. So when the welfare checklist, let's say the welfare checklist is the one we're applying, and we go down, I'll just find the checklist again, and we talk about child's needs. Where is it? Hang on. Not wishes and feelings. So we probably deal with contact under, say, emotional needs, or we probably deal with contact under how capable each parent is. When we deal with that sort of umbrella, sometimes we have a plan of contact once 6 times a year. And what we will say when dealing with that is something along the lines of the child will see the parent 6 times a year. Now that's right. That is our plan. But don't just use that to justify our plan. When you're talking about a child's emotional needs, you will want to expand on that to say, I acknowledge that a reduction in contact will have an emotional impact on this child. I acknowledge the child has a close relationship with their parents, which will suffer as a result of this. However, what is required right now is for this child to understand the difficult decision that has been made. It is for this child to settle in placement and recognize this as their long-term home. And for that reason, I think contact needs to be reduced to send the right message and to allow them to adapt. That is absolutely fine. That is still your plan. But what you've done is you've thrown both sides in there and you've balanced it. And I have seen time and time again, social workers don't do that. Another very great example of that is when you apply the adoption checklist and you've got to talk about the impact of severance of relationships. And there you will have social workers justify the plan. The parents will have contact once a year by letterbox. Well, that's not really enough in terms of you as the expert to the court, telling the court about the impact of severance of relationships on that child. What you need to go in on is the fact that child will be losing the only person they have a relationship with, or the most important people in their lives. The fact that that will have an impact on them long term. But because of their young age, they are still able to attach to a new secure figure, which is what they need to attach to someone who can look after them, who can meet their needs, who won't place them at risk of harm. And so there is a balance exercise that has to take place. And when you, as the expert, has done that balance, you come out on the side of adoption. That is what the court needs to see. Don't just state your plan. So I hope that makes sense to some degree, that you do not use the checklist to justify your plan. Can someone just comment in the box to tell me if that is clear? Because if not, I can give another example. We can go through it again. I would normally do this like hands up or something like that, but Zoom is different, isn't it? I can't wait to see you all in a room. No one's commenting. Have I sent you all to sleep? Yes, makes sense. Thank you, Kathy. Thank you, Vicky. Wonderful. So remember that. And there I've written, concede the negatives to your plan. Don't gloss over it. Now, I think a lot of this stuff you get away with in a lot of cases, because some cases can be really nailed on, and it's obvious the child was not going back to mom or dad. It's obvious there's no family member. But you will all know that there are the 1 or 2 cases where a relative has a good case, or a parent has a good case, or adoption versus long-term foster care is a real issue to grapple with. And in those cases, when you aren't practicing in this way, when you are glossing over these things, when you aren't conceding the positives and balancing it throughout the checklist, it can come back to bite you. So that's why I write, don't gloss over this. The example I've given about the contact, if you're severing ties, is a good one, because it helps to show that you need to grapple with it but still come out on the side you come out with. And actually the court will respect you more for that. I've seen many a judgment where a social worker has gotten in the witness box and justified, both on paper and then amplified in oral evidence, a very good plan of adoption versus long-term foster care. The court's been against that social worker, but has written a very nice judgment in favour of that social worker, saying that the social worker had thought it through properly, clearly understood the issues in the case, but with respect, I disagree for these reasons. That is what you're looking for if you ever lose. And you only get there if you've properly applied that checklist. Concede the positives, which may go against your plan. Now, I have seen many pieces of final evidence from local authorities where the social worker doesn't even write in the plan, the parents love the children. That is at the very least something that you can say as a positive in every piece of final evidence. They love their children. They show up for contact. They've been showing up sometimes for contact. Some of the contact has been positive. All of the contact has been positive. They've answered my call on most of the occasion. They tried to engage with me. During the proceedings, they've engaged with the psychologist. You know, those are positives, that they're tokenistic positives, aren't they? They're not really big deals, but they are enough to show you as a balanced social worker. So make sure that you get that in. Legal, if you're a solicitor on the line working for the authority, remember these points as well, because if you get a piece of final evidence and not a single positive in it, make a section, strengths, and then send it back to the social worker and say, get some strengths in there. Or if you get a checklist application that you think, this is just justifying the plan, there's no analysis under here, send it back to them and make sure you say, apply that properly. So apply your social work knowledge of the case. Remember, no one knows the case like you do, but balance it properly. Think about it and run the arguments on both sides. Apply your knowledge of those particular children and their needs as well. You will have children with more than good enough needs. Don't be scared to say that, but explain why. When it comes to the children's needs as part of the checklist, explain they have higher needs in this, and this area. I tend to find, as counsel who does a lot of local authority work, I can 9 times out of 10 make quite an effective argument along the lines of the children have suffered childhood trauma, have a narrative of abuse, and as a result of that, they will have some higher needs, or they are likely to have higher needs because this can affect them behaviorally in the future. This can affect their development in the future. This can affect their attachments, which then results in behavioral issues in the future. That's an argument I make as counsel, and I've never had that argument knocked back, because, you know, children have suffered abuse if we've got threshold, unless they're newborn baby, they're there. So I would encourage the social workers on the line, if nothing else, you can make those points along the analysis of the checklist, and the court is likely to accept that. Consider the long-term implications of your plan. And again, I'm going back to your adoption versus long-term foster care plans. Really, when you apply these checklists, think about everything. Think about absolutely everything. Think about every negative. Think, if I was the guardian on the other side going long-term foster care, what would I put in this checklist? What would I take to town? And I point them all out. I acknowledge this, I acknowledge this, I acknowledge this, I acknowledge this. However, acknowledge them all. And that way your plan is always watertight. You conceded the negatives, but you justified your plan. And I think that has to do with looking long term into these plans, thinking what's going to happen a year down the line, 2 years, up to the point of reaching majority, and put that all in. So examples of where it goes wrong. We've got severance ties. Absolutely. I've discussed that. Sibling contact issues. That's a nightmare in these kind of plans. And I know that it's a nightmare, but you as a social worker must address it. You can't gloss over this and go, this child's in displacement and that's good for them. You need to be head on. They will suffer a damage to their sibling relationship. However, we will promote it using this, and this to make sure that this stays in place, to make sure that the relationship can be maintained. Acknowledge it. Religious or cultural issues. Again, people gloss over that a lot. They say things like, child needs stability. Well, yes, they need stability. Child needs security. Yes. Predictability. Yes. All that's great. And all that's there for good reason. But don't ignore the fact that you might have religious issues, cultural issues, and deal with them properly. I acknowledge not being raised by a family member will mean that this child who comes from a certain cultural background will not be able to integrate fully into that culture. To mitigate this, we will put them in a foster place, or we will search for foster placements that can provide this, and this. However, the priority must be on providing safe, stable, and secure care, and we will also consider that alongside cultural issues. And then the court knows you haven't ignored it. It might not be where that child ends up. You're doing the best you can with the resources you have, but it's certainly something that's on your radar, and that is normally enough for the court and certainly to get over the guardian, which I know we all see is a huge hurdle. Age of child in an adoption plan. Again, don't ignore that. That's a clever argument to be made. And if you think a child is on the border of 4/5 and you might get a foster care argument, don't ignore it. Deal with it head on. Talk about all the positives, talk about all the negatives, and then do your balance. That's how you've got to deal with it. If you want more information, by the way, on arguments to make for adoption versus long-term foster care, I did a seminar on that a little while back. That's on YouTube, that I always encourage social workers to listen to, because when you write up that final evidence, I always think that's a really tricky piece of final evidence to do, because that's a hard argument that always falls like unpredictably one way or the other. So you want to keep an eye on that one. So that's how you apply the balance sheets and the different factors to consider. And that's what legal should be looking out for as well. The importance of being balanced. Remember, you are the expert. You are not just the advocate for the authority. Put both sides of that so the court can see you have thought about everything and your reasoning for falling on one side is obvious. Remember, the guardian will be more on side if you balance it, because the guardian will see and think, no, I agree with her. She's looked at this, and this, or I agree with him. He's made sure he's covered this, and this. Weigh the options sensibly. Realistic options. Let's talk about that for a minute. I have seen so many care plans and balance sheets where when you look at the different options, what the social worker hasn't done is considered everyone. And what I mean by that is a carer, it's obvious, like if mum's putting herself forward, it's one of the realistic options is placement with mum, and you have to do the pros and cons of that in your balance sheet, and that's absolutely fine. That's what you need to do. But placement with mom has different limbs to it, doesn't it? Placement with mom on the child arrangement order, placement with mom on the care order, and what level of support mom can have on both sides. Then there is the issue of placing both children with mom, placing one child with mom. Now you can have balance sheets that go on for days if you have to analyse these all. And I'm not saying you do, but I am saying make sure you acknowledge in your pros and cons that if a care order was made, it could be propped up in this way. If a supervision order was made, it could be propped up in this way. But if a care order was made, it would have this stigma attached. I will leave it to you as to how you separate that balance sheet and the headings you use. But do not ignore for a moment that there are different options when it comes to placement with mom. And if I was representing a mom, which I do sometimes say to social workers, you've ruled mom out, and that's absolutely fine, but couldn't a care order plug these gaps? Or couldn't mom having the younger child plug this gap, rather than having to juggle the two? And then the social workers are arming and eyeing in the witness box because proper thought hasn't been put to that. So that's why I'm flagging it. And I'm saying, when you do these realistic options, think about all of the options, thinking about What could a care order give? What could one child in placement versus two mean? What could care order versus SGO mean in terms of support? And put them all there, pros and cons. And I've written double check it after you've done the balance sheets, because yes, you do have to do balance sheets. Yes, they are directed and they are important for you to do so the court can see that you have considered all the options. Remember, you're not just there to justify a plan. You have to recognise both sides and do a proper analysis. But what a lot of social workers do is they copy and paste old balance sheets on other cases, because it says, oh, care order placement with mom, and they go back to one that says that, copies and pastes it. Now, I'm not saying don't use that as your starting point, because quite frankly, if I had to do that job, I'd probably start there as well. But when you do that, then look at it and see, do those factors that are in those columns, do they apply to my specific case? Have I changed the pronoun? Because little Timmy being called she in a balance sheet will scream to the judge that you've copied and pasted it. And so look at pronouns, look at the names, look at what pros and cons you have in that list, add to it, remove some if you have to. Just make sure that it is tailored and particularized to your children on your case with your carer seeking your type of order. So that's the importance of the balance sheets. And I didn't put the law there. Actually, I probably should have done. But remember, these care plans have to be REVS compliant, which means that you do have to have, by law, balance sheets to show the court that you have considered every option, balanced the pros and cons, and reached your conclusion sensibly, not just by justifying the authority's plan, but by seeing it from both sides of the coin, because then the court can put the proper weight on your plan. This also applies, if I pause for a moment, to parenting assessments to some degree, because what I'll do, and I'll give you a tip of what I do, is if I ever review a piece of final evidence, under every section, so sorry, when I say final evidence, I mean assessment, parenting assessment, for instance, under every section where it says, meeting the child's basic needs, for instance, I do a mini analysis around that. And then when you get to the conclusion, and what I mean by do, I point out to the social worker to do. When you get to the conclusion, I then use different headings, and I start with strengths. I then go to vulnerabilities. I then go to, could they do it with support? I then go to, could they do it if it's one child, two children, or all three, for instance? And then I go to conclusion. And I do think when you have written like that, you are far less open to criticism, because you showed the court you have thought about it from every angle, and it makes life a lot easier when you will then write up your final evidence, because of course you will then have all of that analysis already done, and you're lifting the arguments and inserting them. So bear that in mind when you do the final evidence, that the parenting assessments, if done properly, can help a lot. Okay, so that's the balance sheet. Let's go to examples. One-sided balance sheets. I've seen that loads, where the social worker just doesn't take the time to see the other side of the coin and to do proper negatives in the column. So make sure you do that. Don't exclude the realistic options. We've talked about that. Don't copy and paste from previous plan, and think through all the negatives. Think through everything that is against your plan and properly deal with it so that you can't be criticised. I always think when I do the pros and cons side, I must have, at the very least, 3 more pros in favour of my plan than against. That could mean that there are 20 reasons against my plan and 23 in favour of my plan. But I make sure I get them all down, because I think if you miss one, that will be the one that's put to you that makes you look like you didn't think about it properly. And so I always think, try it that way. Just sit down and think them through first. Don't copy and paste and then ignore it. And for legal, when it comes to you, just do the same. Have a think of that to assist, because I think sometimes when we don't think about it from all angles ourselves, the social workers are then on the back foot through no fault of anyone's. It's just sometimes the way the cookie crumbles, isn't it? But that's something to look out for. Have they dealt with that properly? And if not, how can we help them? Expert evidence. So I wanted to include this as a very brief topic for us to cover. You all know, I think, that you need to grapple with the expert evidence, A, as part of the parenting assessment, and B, certainly in the final evidence, because you need to write, the expert says this, this, and this. But I think sometimes social workers struggle with, what do we do with that? The answer is this. If the expert is with you, you incorporate what the expert says. It's very, very short. The expert says this, 1 or 2 paragraphs. And then you obviously are not the expert on that. So you can't say, having done my own assessment, I agree. But what you can say is, I can see elements of this in my own practice with the family and give examples of that. Now, what I mean by that is, if you have, for instance, a mother with emotional dysregulation, and the expert talks about the fact that they can't control themselves and that will have an impact on the children, you can then say, I acknowledge the expert says this. In my own experience, I can see signs of this, and gives maybe 3 or 4 examples where that has happened over the course of proceedings, where the mother has struggled with her emotions and that has impacted on the children. And then you are A, showing deference to the expert, and B, what you are doing is you are giving examples to bolster the expert's opinion, so that if that opinion is challenged, you have helped the expert. If they're on your side, help them. Now, if they're against you, what do you do? Well, it's always a harder one, isn't it? If you ask, how many of us have asked for a psychological assessment and they come back and they go, parents fine, nothing wrong from a psychological perspective, and you think, oh crap, I shouldn't have asked for that assessment. What you do then is this: don't ignore it. I've seen social work statements and final plans where they completely gloss over, don't address what the expert says. You have to deal with it. It's not the easiest to deal with, but you have to. You write what the expert says, and then you say, I disagree with them for these reasons. A, it's not what I'm seeing on the ground, and talk about what you see on the ground. B, the expert has seen it from a psychological perspective. I have to look at it holistically, and when I look at it from all angles, these are the factors against it. So, for instance, that case I told you about earlier, the one with the recommendation of a residential placement for the child, the experts say that residential is right for the child, but this child is a 14-year-old who has said quite clearly, if you put me in a residential, I'm going to kick off. I'm going to run away. I'm going to break down this placement. You know, so what I have advised and what has ended up in the plan is, we recognize what the experts say, but at the same time, we, looking at this from the full picture, have to consider that this child is of an age where this child votes with their feet on a regular occasion. And as a result of that, we don't want to put them in a placement where we set them up to fail, because a further breakdown in placement will be more harmful for them. For that reason, we are in discussions with them around a foster placement to make sure that they can provide this, this, and this, and we can plug the gaps in these ways, and you do it that way. And then they can run the argument of, we've looked at this holistically, because the experts aren't there to make a decision that incorporates all the child's wishes and feelings. The expert is there to give an opinion from a psychological perspective of what is right for that child. You, as a social worker on the ground, have the wishes and feelings side of it. You have the relationship with the family, which may mean that they don't want to go to a residential because they are insisting on seeing their family more often than you would perhaps allow in a residential. You have the other side of their educational needs and where they're at in school, and is it right to pull them from school to put them into a residential unit. You have that information as the social worker. It is not easy to go against an expert, but if you incorporate the round picture rather than just the psychological side of it, then you have put forward a compelling argument that you might get the guardian to bite on. And that's the important part, isn't it? So yeah, so that's how you grapple with, in the final evidence, if your plan is different to what an expert says, justify it. Use the checklist and stick your reasoning in. Think about it from the round. So explain what you agree with them about. So what you both agree on, where you differ, why you differ. And remember, you are here to do an holistic exercise. They are limited to their relevant fields of expertise. That's not to say you'll win. But I like to think it's all about putting forward a compelling argument, right? Because you might win 1 or 2. And that's a victory if you go against an expert, in my view. Okay, so to wrap this up then, and I have wrapped it up very well on time, actually, I've put together just some general guidance on how you do this. You all use the SWOT. And I think plans are useful when you've got the SWOT. Plan in every column what it is you're going to say. Use of active language versus passive language. Now, let me cover that very briefly. Linking back to what I said at the beginning about primary evidence, it can be incredibly difficult to decipher final evidence when a social worker writes passively. I think people are raised, from school, we're all raised, aren't we, to not write actively. You're taught not to say I in statements in English, and actually, English classes, I mean, actually, in these kinds of things where you're writing a statement that's your opinion, tells the court what experience you have had, you need to put I in it. So what I see in these statements, let me give you an example. I've had a case recently where the sweat was written about the kind of things the child had discussed about the abuse that they had suffered or allegedly suffered during proceedings. And the social worker just wrote, the child has said this, this, and this. It has come to the attention of the authority, this, this, and this. And I was looking at it and I was thinking, who did that child say it to? When did they say it? What context did they say it in? What questions were asked of them? Was it during direct one-to-one work, or was it in the presence of someone who might have been influencing them? And what order did they say it in? Because they had muddled the whole thing together in this passive language of the child has said, blah, blah, blah. And when I finally managed to have a conference to break that down, these 3 paragraphs of beautiful evidence that had been muddled together was actually something, or were a series of discussions that took place with health visitor, with nursery, with social worker, with granny, and the child had said something different, stroke elaborating to every one of those professionals on different days in different circumstances. I would have never got that from those 3 paragraphs. I would have thought that all of that was just said to the social worker if I didn't explore it further. And that is the danger of passive language in these statements. Tell us who said what, when, and how. Otherwise, we can't tell where the primary evidence comes from, what is hearsay evidence. And for the solicitors and legal, keep an eye on this, because you will have to gather statements from the primary sources of evidence, and you can't do that if the paragraphs are muddled. The other issue that particular case caused me, and it comes on to the next point, dates, times, and chronological order. I could make no sense of what was said when, to whom, and what followed later, and which came first, which comment came first. It just didn't make, like, she'd summarized it all into 3 paragraphs of what the child had said, but she'd done it in such a way that I couldn't tell what was said when and by whom and to whom, and it was really hard to break down. So again, I think when you do these statements, we are looking for active language. I was told by this child on X date this. Mother told me this, this, and this. I was there when I witnessed mother slap the child. I was there when mother was swaying everywhere and slurring her speech. What I don't want to see in these statements is mother was slurring her speech on 2 occasions. When? Who saw it? That doesn't help. And then what will happen is you'll get in the witness box, the court will say, did you see that? And you'll go, no. And the court says, well, I can't, if mother challenges that, I can't give proper weight to that, because the person who did see it isn't here to tell me that. It's hearsay evidence. So be very careful. Write in the active, I saw this, I think this, I did this. And then we will all know what took place. And if something has been said to you, say, John Doe from nursery said this on this date. So then legal and solicitors will know, go to John Doe and get a statement on that issue. And that's the primary evidence. Yeah. So that's the danger with passive language. It's in our bones not to write that way, but please do. Dates, times, chronological order, sequential. Include all relevant details for carers. So I had a case once where, and this probably seems really obvious to everyone, but it was a real issue in that case, where we put forward granny and granddad as the long-term carers. We hadn't filed the connected persons assessment, don't ask me why. And in the final evidence and in the care plans, we'd written their first names and nothing else. And when I was talking to the social worker, I was saying, well, how does anyone know who this is? How does anyone know what their name is? How does anyone know that you've assessed them, done background checks? Actually found out that they're a relevant and appropriate person to care. Or sometimes what you do is they anonymize everything. And I've seen cases where it's, baby, let's pick a name, baby John will be cared for by DB. And I'm like, who's DB? Why can't you just say the name? I think the parents and the judge wants to know who's going to care for the child. Now, I entirely appreciate that if it is at local authority foster carers, that's a different situation. But if it isn't, and you're proposing something, you need to give people proper information about who's going to do what when. Okay, so all relevant details. Avoid repetition. Now, solicitors can some of you comment and tell me, how many of you have had 90-page final statements where it's repeated all the way through the same information, sometimes cut and paste chunks of paragraphs that we put in another place in the statement? Go on, don't be shy. Tell me in the chat box if that's happened to you. Well, I can say that has happened several times to me, that we start the journey, we see this evidence come through, we start to read it, and it just repeats lots and lots of stuff. Don't do it. If you've said it once, just include it, and that way, just include it the once, and that way it will save time. I see quite a few people are talking about the handout in the chat and saying they haven't got it. I'll put my email address again, just so you can have the handout. I cannot take the time right now to write your email addresses, so you're going to have to email me, because if I do that, I'll have to stop the whole seminar to be able to do that. So sorry, guys. But if you email me, I will send it through to you. There you go. There's my email address in the chat. So yes, so only say it once. And if you as a solicitor get it and it's a very long document, just do that. Just cut out those sections as your suggestions. I had a case recently, we went before a recorder, and he's a very no-nonsense advocate, if we put it like that. And he spent about 20 minutes talking about the fact that he had to read a 90-page assessment that could have been a 30-page assessment if the social worker would stop saying the same thing over and over. And I know I shouldn't laugh at that, but it's the way they can get, you can irritate the judge, you can rub them the wrong way even before the hearing starts by doing that. So just don't do it, just cut it back. So what we then have is bring in the views of others. Now, this is perhaps more relevant when you do the parenting assessments, but, oh gosh, it says it's not showing up in your chat. Have you all got my email address now? Has that gone to anyone? It should have done. Hang on, I'll try again. Paste, send. What about now? Should have gone to everyone, that one. Have you all received it? Oh, maybe it should be all attendees. Paste. There you go. See if that works, if you've got it now. Yeah, so bring in the views of others. That's more relevant when you do your parenting assessments. But of course, what I mean by that is you are the social worker, you are the lower E expert in this case. But of course, you don't just make your analysis or your decisions based on your observations. You will have family support workers, you will have contact workers, you will have nursery professionals and school professionals. You may have CAMs giving a view. In your final evidence, it helps if you are really justifying a difficult plan to say, having liaised with school, they say this, having liaised with CAMs, they say this. You will regularly see that guardians do that in their analysis, because it helps to show the court that they've looked at it from all angles. Don't be afraid to do that, because then it will be helpful to the judge to know you're basing this on things that other people are saying. There I've written, recognise and explain where it is hearsay, though. We link back to the primary evidence point. If you are doing that, and if you are going to incorporate something school told you, please tell me, or tell the judge, or tell the parties. Don't just say this, this, and this is what's been observed. You know, this, so let's pick a child, Kayla. Kayla has been observed to lash out, to be difficult, to do this, to do that. And that's the end of that sentence. That is not the end of that sentence. The sentence says, Mr. John Doe from nursery school BAM spoke to me on X date and told me that this, this, and this is the full sentence. Otherwise, the court will not know that that is hearsay evidence, and that can cause you problems later on. So remember to always source your evidence. Where is it coming from? Where are you getting this from? Make it clear to the judge, because then solicitors and legal can also gather that evidence once they know that A, plans are challenged, and B, where it comes from. So that is the important part of why we do that. Don't group evidence in a way that confuses it. The allegations, which is the story I told you about, the 3 paragraphs that took me days to decipher who said what, when, and where. So I think you're all experts now on why we don't do that. So what is the next point on my list? Let's see. Concede the negatives, we've done that. Recognize the positives, we've done that. Apply the correct checklist, we've done that. Address all realistic options, we've done that. And justify your conclusion, weighing all of that together. Remember your little analysis at the end. Now, I know that a lot of the time, social workers can struggle with understanding how to write the analysis. So what we need, what I'll say is, the best way to do it is if you do what I said earlier, which is go through your parenting assessment when you write that, and after every session on basic care, emotional needs, neglect, blah, blah, whatever your headings are going to be, do a little mini analysis at the end. Say, having now completed this section, my view is this for this reason. And when you will go then to do your final justification in the final statement, you will then have the opportunity to use what you've written analysis-wise throughout the parenting assessment to bolster your application of the checklist. And then at the final end, you will say, in conclusion, I recognise that the positives here would be bam, 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 bam if they're placed with mom, bam, bam, bam if placed with dad, bam, bam, bam if placed with auntie, bam, bam, bam if they stay in long-term foster care. But the reality of the situation is they would also be at risk of this harm. They would have their needs inconsistently met. Their more than good enough needs means this, this, and this. And for those reasons, I am led to the conclusion that this has to be the plan that's right for them, as per my application of the checklist. And then the court, that's all. That's your analysis. An analysis, really, people get scared when they hear the word analysis. But the reality is, if you do it the way I suggest, which is the positives, the weaknesses, the can support, plug the gap, could mom or dad care for 1 child, 2 child, 3 child. If you've done those headings in your parenting assessment, then you've done the analysis. And then at the end, all you need to write is 1 or 2 paragraphs to say, overall, this, therefore. And likewise, if you apply the checklist in the final sweat and you recognize the good and the bad under every umbrella, at the end, it's overall this. You've done the analysis. It doesn't have to be that long. So that is your justify, your conclusion, weighing all of that together. Lastly, remember how to apply this to your care plans. Remember, when you write care plans, co-ed care plans, be very clear. Where's that kid going to live? What's the placement going to look like? What type of order and what contact? And I'm focusing on that. Of course, there are other things that you have to consider. Support for the placement, proper reviews, involving parents under the LAC process. Absolutely, all of that has to be considered. And for a moment, I wouldn't suggest otherwise. But I mentioned those 3 because I think the co-edness of the care plan, is co-edness a word? One of you solicitors will tell me. Is something the guardian's going to look at. The support to be properly outlined is something that the guardian will look at, and the contact is what the parents will look at. So I always think on care plans, those are the 3 sections that you really want to nail down, because that's the bit that can get your care plan challenged. So remember that when you draft your care plans, remember and justify it very sensibly in the statement that accompanies the care plan,